At around 11:30 a.m., the former Special Police Commander SSP Agasirwe was arraigned at High Court Criminal Division in Kampala before Judge Isaac Mwata to hear his bail ruling. SSP Agasirwe is faced with one count of murdering Assistant Director of Public Prosecutions Joan Namazzi, which offences he faces with Samujjo Abdul Nur alias Minana. Before Judge Isaac Mwata, after perusing both sides' submissions, he denied SSP Agasirwe's bail application.
The right to interfere with constitutional witnesses, many of whom were his subordinates. The respondents also challenged the applicant's character, noting multiple ongoing investigations for capital offences, including kidnapping, intent to murder, aggravated robbery. Additionally, the respondent revealed that land title presented as proof of evidence, proof of residence, is currently under investigation by the CID. An allegation is that it was acquired through illicit enrichment. The representation at the hearing, counsel Michael Kampira appeared for the applicant, while Richard William appeared for the state. They both filed their submissions, which I have considered. The law applicable to bail is settled in Uganda versus Kanochiza Jail, the citation of the Constitution. Under Article 26, Article 6 of the Constitution, the court has the discretion to grant bail on such conditions as it considers reasonable. However, this discretion must be exercised while balancing the constitutional rights of the applicant against the needs of society to be protected from lawlessness, as noted in another case of Onebe versus Uganda. Regarding mandatory bail, the applicant contends that he is entitled to mandatory bail under Article 26C, having spent 184 days on remand. However, the record indicates that the DPP filed an indictment on several evidence on the 16th of December 2026. Sorry, 2025. The purpose of the 180-day threshold is to prevent the state from holding citizens indefinitely without formalizing their charges. By filing these documents, the state fulfilled its obligation, qualified that the mandatory grants have been overtaken by the criminal proceedings. The state has demonstrated its readiness to proceed, and therefore the applicant can no longer be kept waiting for trial. Under paragraph 13C of the bail guidelines, the court must consider the applicant's character and antecedents. While the applicant claims to be law-abiding, the respondent revealed a list of active capital cases, investigations, and one is kidnapping with intent to murder, aggravated robbery, and murder CRB 161 of 2016, two murder RRU CRB 108 of 2010, then murder massacre CRB 2040-204. Then illicit enrichment, as I've already referred to above. This active investigation is really a challenge to the bail application. While the applicant has no prior conviction and is still presumed innocent, the sheer volume of active capital files investigation suggests a pattern of alleged criminal conduct that the court cannot ignore. Releasing the applicant while these files are active will jeopardize the state's ability to conclude these investigations and may provide the applicant with the opportunity to interfere with those investigations. The court has carefully weighed the applicant's constitutional right to liberty and his history of compliance with the previous commercial proceedings. However, this must be balanced against the gravity of the current murder charge and the multiple active capital investigations cited by the state. the failure to substantively explain the status of this active investigation is.
Judge Isaac Mwata added that following the pending criminal files against the accused and other files which are still under investigations, the accused Agasirwe can't be granted bail.
Combined with the fact that the applicant has now been committed for trial and the fact that the applicant has not proved the exceptional circumstances that justify his release on bail, creates an unacceptably high risk that the interest of justice will be prejudiced by his release. At this stage, accordingly, the application for bail is hereby dismissed. So order. Yeah. Everything is ready.
According to court records, basing on Agasirwe's character and antecedents, although he claims to be a law-abiding citizen, the prosecution reviewed a list of capital offences under investigations, among others kidnap with intent to murder, aggravated robbery and murder that happened in Masaka, and a list enrichment file pending against him at CID. SSP Nixon Agasirwe applying for bail, alleged being his constitutional right, being a first-time offender, advanced age of 54, and that he has a permanent place of abode. However, all the grounds were objected by the prosecution, led by the Assistant Director of Public Prosecution Richard Billy Vomboka. Trouble for Nixon Agasirwe started following the evidence in chief by Ewan Kiseka, a convict, in the murder case of Assistant DPP Joan Namazekagezi, who pinned the SSP Nixon Agasirwe to have been the mastermind behind the murder of Joan Namazekagezi. The evidence in the International War Crimes Division Court led to the arrest of Nixon Agasirwe and Ewan Abdulnur Semuju alias Minana by security operatives.